Howdy, howdy, howdy. Hope everybody's good. I goofed up every time I try to set up something using AI, I end up with a dark screen. So, maybe it would be better. Maybe I'll try one of these just with a dark screen without me, just with a voiceover. Maybe that would work better. Maybe that'd be an interesting change. To those who followed the change, as I bend over so I could see your names, hello again, Mr. StreamYard. Hello, Jason, Alan, Thomas. Alan is my middle name, Alan, which looks like it's a different spelling. Thomas Lee, Gator Boy, I like that. Tim, Renee, Lucid, the 1-1. Since I goofed up in terms of the first starting point, I'm gonna wait a few seconds just to give people a chance to kind of catch up to the change. See anybody else? Kerr, D, that's pretty easy on my part. Cruteau, is that how I pronounce it? Croto. Okay, thank you. Thanks for putting in there. Nared or Nared. Wow, I'm terrible at pronunciations. I take full credit for being terrible at pronunciations. Anybody, whoever is here, welcome. So as seems to happen more than once, I will do a live stream and then coincidentally stuff will happen and I'll need to kind of follow up. So yesterday's live stream really wasn't that significant, had not a lot to say. I kind of went through a bunch of questions that I had thrown off to counsel to the receiver, and lo and behold, they responded, and there was a couple filings. So there's a bunch of stuff to talk about that we didn't talk about yesterday, and we could talk about what the implications are of that too. And you could draw your own conclusions. Before we start, of course, this is not legal advice, which I don't really say very much. Please like, subscribe, send billions of dollars to, and anything else you want to do. This certainly is not legal advice, even if it is. By the way, I'm doing a tomorrow morning 6:30 Pacific time with Alexandra Mertz and Herbert on Tesla, watching the Delaware Supreme Court rule on or conduct hearings on the Elon Musk pay package. So if you're up on the West Coast or the East Coast, join them. It won't be on my channel, but I'll be there commenting about like the judge's uniform, about how their hair was done, about how the mic stand look, and all the other really interesting things that happened in the courtroom. Joking, of course. By the way, if you knew me personally, it's funny. If you knew me personally, about 95% of what I say, I would be joking in interpersonally, and eventually you'd understand it. But at first, you'd give me these looks like you couldn't believe I was saying what I was saying. But anyway, before I start, one bird cannot make a pun, but two can. What do you call a cow with only two legs? Eileen. Did you hear about the trending corduroy pillows? They're making headlines. And last but not least, in the first round at least, did you hear about the guy who lost a job at the blanket factory? Apparently it folded. Anyway, so yesterday I did a live stream about, I don't know what I talked about, more BS stuff. Talked about, I talked about the most recent communication I sent to the Receivers Council, and it was Sunday. And on Monday, I got a response. So I figured it was worthwhile talking about the response. The same time on Monday, yesterday was Monday, there were two filings that are very relevant, and I wanted to talk about those too. And that's what we're going to talk about. So first of all, and I'm just going to basically tell you the question and then the response, and I think this is kind of helpful. And I'll give credit to the Receivers Council for responding, even if it takes a little bit of prompting, but I appreciate it. Appreciate the response. So here it goes. So the first kind of question I had was about the monetary claims, my recollection, and I'm summarizing, I'm not reading directly, but I said, my recollection was about the claims that were being filed against GTII, that you're going to provide some kind of summary, and where is that? That's basically the question. The answer is they're coming with the next report. Okay, that's the response. The next question asks about the trying to get the trading halted, and they give a response that they've already responded about that. I don't really think it's been responsive, but they do. I haven't decided if I'm going to ask them for further clarification, but they indicate that they think they've responded and they think they've given reason for not attempting to limit trading, but it's hard to tell from the response, honestly. So it's not really clear. So I'm going to think I'm going to try to delve a little further, but they did respond in some fashion to that. Then next I asked about, if you recall, I asked about the status of depositions and the document production. The response is the documents aren't due to the 19th. As to the depositions, there are some that are likely forthcoming, but they don't want to disclose it yet because they don't want it to impact negotiations. But I suspect one will go out for Luke Rabari. That's in relation to the disputed shares. He's represented by GT. I don't know who that is. GT, maybe that's GTII. I don't know who that GT refers to. GT, I don't know. I expect the next report will have a roadmap of sorts for depositions and or litigation. So it's a good response. So the first deposition was Frank. They're indicating that they're probably going to do Luke's as to the disputed shares, and that in the report that they will probably lay out a framework for any future depositions or the litigation. Next question, any time frame for your next reporting? And this, I think, kind of is helpful. One way or the other. So I'm asking when's the next report coming out? One way or another, it will occur this month. This month being October. It's now October 14th. So kind of within 2 weeks or so, we will see the report. And he's indicated a bunch of topics, and you'll continue to hear that will be addressed in the report. For example, he said he's going to give a roadmap for depositions or litigation. I think he mentioned something prior to that. What else did he mention? He mentioned about the monetary claims, that they be referenced summarized in the report. So that's helpful. Let me actually read what he said about the reporting, just because it has more than just that. One way or the other, it will occur this month. What is contained will depend on what happens with the audit, etc., which has been the delay. So it's not saying that, but let me read into it. Sounds like the audit must be far enough along that they were delaying reporting, hoping that the audit had been completed. That's just my speculation. I don't know that for the fact, but it sounds like by this statement that the audit would be far along. That's just my conclusion. And again, because he's asserting that the delay in the reporting is because of the audit. So why would they come forward and report unless there had been substantial progress in the audit, or it was close to being done, or whatever? We will see, but that's kind of what it's suggesting. Any update? My next question. Any update, Ray, the audit completion? His response, it's materially progressing. I know that's not the answer you want, but I'm hopeful. Next one. Any update, Ray, status of negotiations with AIV or anyone else? AIV is AIversity. Answer, nothing to report, but likewise, it will be discussed in the report. So there's a bunch of issues, again, that they've referenced, and he's indicated that the report will be forthcoming this month, which is within the next couple weeks, and that he's already indicated the number of topics that will be discussed, including the status of negotiations. Any update? My question. Any update regarding the status of any negotiations to get the return of disputed shares? This will be fleshed out in the report. Again, another topic that will be discussed within 2 weeks. And I expect when they say fleshed out that it will be substantially clarified what the status is. Any update? And I threw in one just to think he was paying attention and to test his sense of humor. I said, any update when the A's ballpark will be finished, because it's being completed in Las Vegas? And his answer was 2028. So he does have a sense of humor, so I have to give him that. When is the next court date was my next question. With the report, I'll set a status check. And that's it. So that's the response to my questions. He basically said that a lot of this stuff will be recovered in the report that will be forthcoming within the next 2 weeks or so. And so I think that's helpful, and at least that will get us at least current in terms of some events. Now let's go to some other things that occurred that we're all interested in. First of all, there was a stipulation and order that was filed and signed by the court. It was filed yesterday, October 13th. Yeah, October 13th at about 4 p.m. And basically what it is a stipulation. So if you recall, there was time limits by which parties could submit certain claims. And the time limit was September 15th. I think it was extended for Bronx Eye Care. Anyway, here, what has happened is there is an agreement to extend the date by which David Reichman can file any kind of claim related either to, a claim of ownership, or it appears like it would even be, perhaps it might include the disputed shares. And I'll explain that in a second. But it was the bar date that was September 15th. So they're asking that the court agreed to extend that to October 31st of 2025. What the language that's of interest, though, is paragraph 5. And what it says is the receiver and Reichman, and again, this is referring to David Reichman, and you'll see why I know it's David Reichman and not some other Reichman. The receiver and Reichman are in discussions concerning a potential settlement of claims and related releases, which will be subject to this court's approval. So, based upon the representation to the court that the receiver and the receiver's counsel is negotiating a potential resolution of, I would guess, all claims and probably all disputed shares. And I don't know that, but I'm just getting the suggestion would be, if you were going to resolve claims, I think you'd want to resolve all the claims unless you couldn't. And perhaps this just relates to monetary claims, but it suggests to me that it's bigger, that they're discussing a potential settlement of claims and related releases. But anyway, that's the reason why the date's extended. So could there be some kind of agreement that's entered into between the receiver and David Reichman, whereby either he gives up his claims and gives up shares, or the receiver releases certain claims in response to Reichman returning shares or money? Could that be in the works? It certainly could be in the works, and that's what kind of suggesting. Which one it applies to, whether it's just monetary claims or is it including the disputed shares, that's what we don't know. The extending the date to October 31st, since we're already at October 14th, I don't think is meaningful. It has to be approved by the court, so that's interesting, and we'll have a chance. So any settlement that's reached, I think that's the idea and the understanding, that any agreement or settlement that's reached will have to be subject to court approval. And I hope it's understood that it's court approval with there being an opportunity for people to object. I don't know if that's clear. Because like these stipulations, for example, result in an order, but nobody sees them until they're entered. So perhaps that's a point that's a point I'm going to investigate with Receivers Council. Because it's not just that the court has to approve. Shouldn't they have input from others before they approve? And should it be not at the last minute? And I don't know what specifically I have in mind, but I certainly, talking about it out loud, I'm going to follow up on about that. But that's the indication that there's movement with David Reichman. And, I'm mixed because I don't mind if the guy goes to jail with nothing. I don't mind if that was the case, if he deserved that, if it turned out that he deserved that based upon the receiver's reports to date. That's what he's suggesting. But that conduct occurred, but who knows? So that's one. So we know that there's negotiations between the receiver and David Reichman that likely will conclude by October 30th in one way or the other, and it might relate to all claims that the receiver has against Reichman. It could relate to disputed shares. We don't know, but it relates to certainly a material item related to those parties. So it'll be interesting to find out. We'll know within 2 weeks, and I will follow up with the receiver about that. And I'm going to ask you guys out there, any of you that are in the plaintiffs group who are represented by Alex Calloway in Nevada, I would appreciate if you agree with what I'm asking you to do. And then I would appreciate you do the following. If you know anybody who is in that plaintiffs group represented by Alex Calloway, if you could reach out to them, and could you direct, if you agree, direct your counsel to contact the Receivers Council to make it clear that any settlement of any monetary claim or any claim regarding disputed shares requires a hearing and an opportunity to oppose and to object. So if you're in that plaintiffs group and you agree with what I said, that everybody should have an opportunity to comment on any settlement, and there should be a hearing, not just an order that comes out without anybody being able to process it. If you're in that plaintiffs group and represented by Alex Calloway in Nevada, please reach out, and you agree with what I'm saying, please reach out to them and direct them to contact the Receivers Council to make sure that any settlement must be in a hearing with an opportunity for everybody to participate. So that's really important. So please reach out. I will reach out to the Receivers Council also directly, but if you're represented by Alex Calloway and that law firm in Nevada, then you have somebody who's representing you to do that, and that would be helpful. And if a bunch of you do it, that'll be more persuasive, of course. And if you don't agree again, then just ignore what I just said. So that's interesting. The second part, and that's why I was specific about David Reichman, yesterday also after my live stream, not because of the live stream, non-party Justine Reichman submitted an objection and challenge to the receiver's designation of disputed shares. So Justine Reichman, who hasn't been sued yet, and if you recall, or maybe you don't recall, I think JR does. And I'm going to see JR, by the way, to those who you know JR. I'm going to see JR in Denver in early November. If any of you happen to be out there in Denver on a Saturday in early November and want to join us, then, we'll have a time somewhere in Denver. If not, then so be it also. but I've been yapping about going after Justine, and I specifically said that she should be sued multiple times. She should be sued in California. You should file lis pendens or some kind of attachment order. Um, I don't know why it hasn't been done, but I thought that was really an obvious thing to do. So, with that as a context, so Justine Reichman filed, through her counsel, of course, filed an objection. First of all, she objected to jurisdiction. In other words, um, if if you're like living in South Carolina and have never been to Nevada and have never done business with anybody in Nevada and have no contract with anybody in Nevada, and you've never been in Nevada, and Joe Blow sued you in Nevada, a court in Nevada would not have jurisdiction over you. So there could be no order judgment entered in against you because they don't have any way of being able to rule against you. If, on the other hand, you had a company that was situated in Nevada, and maybe the Nevada laws say that if you have a company, then you're submitting to the jurisdiction of the state, then under that circumstance, then under the same circumstances, the court in Nevada would have jurisdiction over you. So in this circumstance, the preliminary statement that Justine Reichman's counsel is indicating is she's not in Nevada, therefore the court doesn't have jurisdiction over her. The problem is that she's involved, I think, with multiple, and again, I don't know this for a fact because I don't have firsthand knowledge about that, but that she's either been involved with other Nevada entities and therefore has submitted to jurisdiction already. And perhaps the deposition when she was deposed, I think, as to .8 early on in this matter, and that might be submitting to the jurisdiction of the court. But if she hasn't submitted to the jurisdiction of the court, after I saw this, I think I sent it today. I've let them know this many times because I disagree with them on this point. But I sent a email to the Receivers Council saying, I think you should give, and you'll see what I mean when we go through this document, which isn't too long. I think we should give Justine Reichman her request and sue her in California and go after her property and let her get what she wants, apparently, by this objection. And I would have done that day one. And I don't understand why I'm raising it again. And I raised it because I think it would have expedited things immensely and we wouldn't be sitting here a year later. That's Monday morning quarterbacking, of course. But if you say it at the time, it's not. And I've been saying it the whole time. But I think it was obvious that should have been done. I still don't know why it's not been done, but it wasn't done. And so in this objection, the first objection is there's no personal jurisdiction because she's a California resident, not a party to this action. She's never been an officer and director of GTII. So that's what she's basically saying. I think she might have submitted to jurisdiction, but you could have sued her in California and this would be a non-issue and we would have been way down the line in California. If the receiver was appointed a year ago and if they would have filed an action in California a year ago, we'd probably be close to trial on that case. That case would have been over. There would have been a lot of pressure. Again, I'm not Monday morning quarterbacking because I said it at the time multiple times. Objection number 2. The receivership order does not authorize the receiver's process. I don't really understand the argument, but basically what they're saying is that the order that set up the process for disputed shares doesn't appropriately or doesn't have the power to appropriately shift the burden of proof so that the person has the disputed shares shouldn't have the burden to prove that they have legitimate shares. It should be the other way around. That's the objection. Again, I don't think it's particularly persuasive. I also note that there's no declaration. I didn't see a declaration that was filed. You know, it would be interesting. I would think that if there was an objection to the shares, that it should be there should be some declaration that reflects the factual basis for this, but it's absent. Um, the next objection: the receiver must file a separate action to seize property from a non-party. They're saying that you have to file a separate action. Now, I would have filed a separate action, but I think the receivership order certainly gives the receiver the power to get property back from anybody connected to that has property connected to the receivership. So I disagree with them. Although, again, I would have sued her directly in California a long time ago and been as aggressive as possible in a legal way, of course. Fourth objection: there's been no discovery, and the receiver has the burden of proof. Kind of what I was saying before. We were too early in the ball game, and we don't really know the facts. So how could you basically, rule that on this? 5, objection that the statements by the receiver are not specific enough. Some of these just sound like BS objections, by the way. That's a BS objection. There's a statute of limitations objection. That's a BS objection. Why would I say the statute of limitations is a BS objection? This is my conclusion. Because if you have fraud and you're concealing fraud, and fraud would have, at least in California, you'd have a 3 or 4 year statute of limitations, but it's when you discover or should have discovered, and if it's suppressed, then you can have a long tail, and we're not that far out. So I think a statute of limitations objection is kind of another BS objection. I don't think it's well taken myself, even though, again, I think action should have been filed in California. Last but not least, that some Nevada section bars the receiver from clawing back shares he believes were issued for insufficient consideration. I don't even know if he claims they were issued for insufficient consideration. I think thinks they were just bogus shares. Not only were they issued for no consideration, but they shouldn't have been issued at all. I think that's the real issue. And then there's a reservation of rights that says basically that, yeah, we haven't said everything we have, and we have a right to supplement this or the objection. So I find this document pretty weak, but should take into account that Justine Reichman didn't go voluntarily. She certainly didn't agree. And again, if you're not, I would have done this from day one, but I think at this point in time, there is no reason, zero, not to take her up on her request. She's asked to be sued in California, so take her up on her request. Such nonsense. So that's I assume there'll be a response to the objection, although I don't know when the response will be. I'm going to contact them about this, that there's no declaration also. I'm going to contact the Receivers Council and kind of reference the lack of a declaration. So it is interesting that on one hand, we have what sounds to be negotiations ongoing with David Reichman, and the other hand, we have what doesn't sound to be negotiations happening with Justine Reichman, and her counsel literally begging the receiver to sue them in California. And again, I really think you should give them their wish and sue them in California for fraud and whatever else would apply, to the extent they would apply based upon the receiver's reports, based upon what the receiver reports. And again, I've never understood why they haven't, based upon what the receiver says in the reports. If what the receiver says is accurate, and I have to presume what the receiver says is accurate because he's submitting them to the court, then there are more than sufficient allegations to have filed an action against Justine Reichman in California long before today. And again, in this objection, you just have to convert it to like a request to be sued in California. Whatever, give her what she wants. So Just to summarize, so the Receivers Council has responded. Oh, one additional thing: the Receivers Council did confirm that the receiver has not sold any of his shares, or I think he put it, to the best of my understanding, he has not sold any of his shares. So, as far as he knows, the receiver hasn't sold any of his shares, the shares that he's obtained so far in this matter. So that was another thing that he told me in a separate email that I got, I think, yesterday. So just to go over that, so the receiver has kind of responded to my various bullet points. He's indicated that a lot of that stuff will be addressed in the next report. He's indicated that the report will come out before the end of the month, one way or the other. So that's within the next 2 weeks. Then we went through the order and a stipulation that extended the date by which David Reichman can file a claim, which suggested, more than suggested, that indicated that there were negotiations ongoing to try to settle the claims and with appropriate releases. And I was speculating whether that just applied to claims or does that apply to the disputed shares? And I'm guessing it probably applies to both, but we don't know that yet. But I would assume, since the date was extended to October 30th, that we'll know by then if there's an agreement or not, or a partial agreement or whatever, or there's a need for additional time. I guess that's a part also. And the last thing we talked about was an objection that Justine Reichman's counsel filed. And I don't know who's paying for this, by the way. Be interesting to find out who's paying for the defense. Is it GTII? Is it, where do the money's funds come from to pay for the defense? But anyway, there's an objection that's filed by Justine Reichman, who basically objects to the jurisdiction of the Nevada court, where she's a non-party to the present action in this action disputing her shares. And in my mind, she's just asking to be sued in California, something that I've recommended for the past year, which I think it's obvious, and I think it should be done. And that's what brings us up to speed as of today. So maybe tomorrow there'll be something new. We will see. We'll see what happens with the David Reichman and GTI receiver negotiations. We'll see what happens with regard to Justine Reichman's objection. We'll see what happens and what's included in the report that will be coming out in the next couple of weeks. And as things break, as new information is disclosed, of course, I will bring you up to date to the best I can. And before I let you go, if I could find it, I have a couple things to say. And hi, David, and hi, Barbara. I once, I've used this joke before, so I want to see if any of you remember it. This is more of a memory test. I once read a book about anti-gravity. I couldn't put it down. Dogs can't operate MRI machines, but cats can. What do French hedgehogs see on Groundhog's Day? Their chateau. Did you hear about the guy who went to the seafood yoga class? He pulled a muscle. And last but not least, people who don't know the difference between entomology and etymology bug me in ways I cannot put into words. Anyway, to all of you that hung out here, hello, and thank you very much. Have a great day. Any questions, comments, feel free to do both, even in response to this. And hope everybody's well. Take care. Talk to you soon. Be well. See you soon. That's it.